Kinstrand, you may start your argument.
Thank you, Your Honor. And may it please the court and counsel, my name is Rachel Kinstrand and I represent the defendant Robert Bonner. Bonner argues in this appeal that he received the unreasonable assistance of post-conviction counsel. Illinois case law and Rule 651C require counsel to review the record and make any amendments necessary to the petition. Here, counsel's compliance with the rule is rebutted. Even a cursory review of the docket sheet in this case would have revealed that this court, on direct appeal, remanded Bonner's case for Rule 605B admonishments and the opportunity to file a post-judgment motion. On direct appeal, the state agreed with Bonner that this remand was required. In light of the procedural history, it is hard to fathom why counsel would amend Bonner's petition to allege direct appeal counsel's ineffectiveness for not challenging his sentence. Direct appeal counsel cannot be ineffective under these circumstances where Bonner's case was appropriately remanded because the trial court gave no post-plea admonishments. Moreover, counsel's failure to review the record also impacted Bonner's argument that he was not culpably negligent in his late filing. Culpable negligence under Illinois law is akin to recklessness, and here, counsel failed to amend the petition to explain that Bonner's late filing should be excused, where he was denied the relief he was given on direct appeal. The opportunity to file...
Counsel, would it be fair to state that the time for filing begins to run when there's a final order in the original case?
Right, well, you can only appeal from a final order. So
what is the final order in this case following remand when there were two motions pending and never resolved?
That's an excellent point, Your Honor. I think that would be grounds for reversal because I don't think there actually has been a final order based on the failure to obtain a ruling on either of the post-judgment motions. I honestly don't know what happened in this case. It's clear he was writted. Mr. Bonner was writted for his post-plea admonishments, and then both motions were timely filed. And then in August, the mandate was issued, but then the case was administratively closed. So it's clear there was some sort of mix-up, but I don't think...
The mandate was issued in March, and then there was an order in the docket. It's not clear if it's by a judge or the clerk administratively that showed the case being closed, and it repeated the same language from the mandate from March. So I'm a little bit lost as to the sequence myself.
Yeah, I mean, again, the docket sheet doesn't clear it up, but I would just point out for the purposes of second stage proceedings, I don't think it rebuts anything that I've been saying in terms of the arguments. I think, you're absolutely right. And that's a point that I didn't catch in briefing this case, but really if there is no ruling, there is no final order. And again, that just speaks to the fact that the relief on direct appeal should have been followed through on.
I don't know where the line...
I'm sorry. Go ahead.
I was going to say, I don't know where the line is drawn. Like if he had appealed from that docket entry, whatever that was, I think there's a chance we might have said, that's not a final order, send it back. But is there not a point at which his inaction, as imprecise as the turning point may be, makes the case over?
So if I can just add to that, that's really the point I wanted to hone in on as well a little bit. I mean, if we can assume that the defendant would have wanted to go ahead with these post-plea motions following the remand, was it not his responsibility to obtain a ruling from the trial court? And if not, why not?
Well, I think that the answer is really twofold. I think it stems from plea counsel's responsibility to follow through on Rule 604D and have that conversation with him. I mean, there was no additional 604D certificate filed with these new motions following remand. And I think maybe had that happened, the argument we would have had is a little bit different. But I think if you take the lack of the any kind of presumption that there was a discussion about these motions and what was in these motions, coupled with his severe mental illness, I don't think I don't think it's just fair, just from a fairness standpoint, to say that he should be deprived of these the relief he sought on direct appeal and was awarded. Because of the delay in this case. I mean, certainly when you've had counsel that's failed to file a notice of appeal, even when there's been a delay, we've still allowed post-conviction relief for the opportunity to perfect his appeal. And I sort of analogize this case to that. I mean, and obviously, if he's filing this post-conviction petition and having some sort of conversation with his post-conviction counsel, nobody was aware of this having taken place. I mean, I don't know what those conversations were with post-conviction counsel and my client, but my client clearly was unaware of this, and he should have been, right? He is entitled to counsel on the post-plea motions. And so to me, it speaks to just a
Strickland,
failure on a couple different levels.
Constitutionally, right?
Yeah.
That's at the constitutional stage because we're still in the trial stage, the immediate post-plea stage. This isn't just the right to counsel under the Post-Conviction Act. This is Strickland, constitutional.
Well, yeah, on the post plea motions,
On
right?
remand, yeah.
But I guess, also, Your Honor, it's a due process right. If Illinois, you don't have to set up post-conviction proceedings, but if you do, you have to follow through and provide them with some measure of due process. So not to sound like I'm rehashing this, but second stage, taking the facts as true, I think a remand would be appropriate here.
And that's what I wanted to ask you about, actually. I thought you would cover this, and we're bringing it up early in our oral argument today. But in your conclusion, you ask really for two forms of relief. One, that you request that this court vacate the dismissal of the second stage post-conviction petition and then remand to the circuit court for the appointment of counsel and the opportunity to file new post-plea motions, including a motion to withdraw the guilty plea and or a motion to reconsider. But you alternately ask for a new second stage post-conviction proceedings or remand for that, and the appointment of new counsel. So my question is, which one of these do you prefer and why? And if we were to remand for second stage post-conviction proceedings, how do you envision those? What would happen?
Well, I think going along the point that Justice Doherty was making, I think ultimately what the relief is to remand for new post-plea admonishments. So the opportunity for him to file a new motion to withdraw his guilty plea and a new motion to reconsider his sentence. I think
Didn't
ultimately
he get the admonishments though? Is it? The
he
record
did.
shows
I think the record fairly reflects that he got his 605B admonishments because based on what was in the record. Now, I pointed out there was, we did try to get more information. We got the affidavit from the court reporter saying there weren't any transcripts from the date. And I will say both our office and your district, we tried to pull the file, but the files have been destroyed because of the time. So, in terms of getting the actual motion that was filed in the appellate court on direct appeal, we just don't have it. But in a long way of answering Justice Zinoff's question, I think ultimately the relief is to fulfill what happened on direct appeal, because these claims are all even if you had an ineffective assistance of appellate counsel claim, you would still want it to go back for a hearing on his motion to reconsider. So to me, it seems most efficient to send it back to have the direct appeal relief fulfilled. But I argue as an alternative, recognizing the lateness of his petition, the problems with the way the amended petition was drafted, and certainly, to the extent there's questions about his culpable negligence, all of this could be considered at second stage. But I think the preferred method would just to give him his relief on direct appeal, especially if you think there's no judgment to appeal from, no final judgment. So is there,
Are there not, I mean, this is a civil action. Are there not principles of abandonment that could be laid at the feet of your client? Maybe not after 3 months or
again, I think the abandonment, I think it really comes
14
down.
years.
Yeah, I think it really, I can't do anything about that. I take the record as I find it. But I think that to the extent there's legitimate questions about his mental health, in some cases where we're dealing with a severely mentally ill client, post-conviction counsel will go back and get records from the institution to support just how difficult it would have been for him to prepare a post-conviction petition and to seek pro se relief. And, the service of process in this case indicates he was in Joliet. I have no reason to believe that he hasn't been getting, mental health treatment and needed mental health treatment. And that would be the type of thing that I think would call for an evidentiary hearing if the court wanted to go that route. That I don't think it's an intentional abandonment. I don't, again, I don't think there was the lack of a 604D on these post plea motions, the fact that he was writted for the admonishments, but then not writted again in May. Speaks to there being just a total miscommunication or a lack of communication. And I don't think the client would have proceeded this way if he had the fulfillment of his direct appeal.
Are these questions themselves subject to being answered in the context of the post-conviction petition? Not here, but factually at the trial court? Meaning, did he abandon it? Was he inexcusably neglectful? Are these issues that would be inappropriate for us to opine on, but perhaps subject to the scope of a remand?
Well, they would be subject to an evidentiary hearing, which would be a third stage. What I'm suggesting is I don't think as a matter of law, he should be found culpably negligent. I think he should be given an opportunity to amend that petition, basically because, again, on the face of this 651C certificate, post-conviction counsel was unreasonable. I mean, I think this is fairly rebutted by everything in the appellate record and everything that took place. So under Addison, you wouldn't even get to the merits of it. You would send it back for new second stage proceedings, the opportunity to amend this and then go forward. And as I pointed out in the briefs in this case, I'm sure there's more that could be gleaned in his record to support that culpable negligence, not the least of which is that he didn't have a hearing on these post plea motions. So I can continue with my argument unless the court, okay.
Go ahead.
I'm sorry.
Go ahead.
Okay, thank you. The state's arguments that the record is somehow incomplete in this case, or that Bonner was responsible for ensuring that his motions were heard, lack merit. It is clear that the admonishments following remand were given, but that a court reporter was not present, as shown by the docket and the reporter's affidavit. And Bonner had the right to effective assistance of plea counsel, who should have pursued a hearing on the motions he filed. Reasonable post-conviction counsel could have raised that issue in an amended petition. Ultimately, Bonner was denied the fulfillment of his direct appeal, and the state seeks to deprive him of any relief that he was originally awarded by being too late. But on remand and in his post-conviction proceedings, he was deprived of the right to counsel, reasonable or otherwise. This court should either remand for new second stage proceedings and the appointment of counsel, or remand for Bonner's ability to file new post-judgment motions and for a hearing on those motions based on his unfulfilled direct appeal. So I have nothing else unless the court has further questions.
I don't see any at this time. You'll have time on rebuttal. Thank you. Mr. Kelleher?
May it please the court, counsel. the trial court properly dismissed defendant's petition at the second stage, and post-conviction counsel provided a reasonable level of assistance. First of all,
How can it be reasonable to formulate the argument that appellate counsel was ineffective when appellate counsel won and secured the relief that he needed to proceed along with his direct appeal? How can you possibly construe appellate counsel's representation as ineffective?
appellate counsel's representation was not ineffective.
But that was the PC petition that PC counsel drafted. Instead of looking at all at what happened in the remand window, he said appellate counsel was ineffective.
PC counsel claimed that appellate counsel was ineffective, Your Honor, for not filing a motion to reconsider the sentence. So PC counsel thought that the best claim available based on all the circumstances, his review of the case and the record, was to challenge defendant's sentence.
Well, maybe he would have done that, but he won on the preliminary step of securing the remand. And that may have been the next shoe to drop. But
yes, but Your Honor, it's correct. This court did grant defendant a remand so that he could be properly admonished.
And the state conceded that.
Yes, there's no question about that, pursuant to 605B.
Right. So we don't know what the posture, the record would have looked like for appellate counsel to have made any of these arguments on direct appeal, because the appeal never happened. And finding that that's ineffective is just kind of mind-blowing.
Well, actually, the direct appeal
Never complete, never on the merits.
What the direct appeal did, to my understanding, is it remanded the case so that the trial court could properly admonish defendant pursuant to Rule 605B. And that's exactly what happened when the case was remanded. Now, there isn't a record, transcript of proceedings, but there is a docket entry that indicates that the trial court did admonish defendant upon remand properly, and I don't think anyone here is disputing that.
Well, the record doesn't show it was proper. We do know that the record reflects that it was an admonishment attempted, but there's apparently no transcript.
Right. Well, we also know that trial counsel on remand filed two motions, a motion to withdraw defendant's plea of guilty and also a motion to reconsider sentence. So that's supports the conclusion that he was properly admonished pursuant to 605B. He got the relief that the appellate court wanted.
Well, I don't think the appellate court just wanted the motions filed, though.
But the appellate court, by remanding the case, it wasn't compelling defendant to proceed on the motions. It was giving him an opportunity to file the motions. And that's exactly what he did. He had the opportunity. But what's missing from this argument is the fact that in many cases where a defendant seeks to withdraw a guilty plea, he or she ends up getting cold feet, because the more he thinks about it, the more he realizes, hey, I'm taking an enormous gamble by withdrawing my guilty plea, and I could end up in much worse shape if...
Isn't that purely speculation? Because what I can see is those motions were filed in May and the record goes completely silent. So he's in Joliet. His lawyers are in Springfield. Why would we assume that he had some conversation with counsel telling him, don't go ahead and notice up my motions?
Well, that's where the case law comes in, as far as Justice Zinoff suggested, in general, a party filing a motion is responsible
He
for
didn't file it,
obtaining-
right? It
Well,
was his
his-
counsel.
his
It was his
counsel did.
counsel who filed it, and he's entitled to the effective representation. of
On
those-
behalf of, yes, on behalf of the defendant, but nevertheless, he has the responsibility of obtaining a ruling from the trial court on the motion. And this court in Rogachev just recently addressed that, and they quoted the Illinois Supreme Court, the Broussard
Was that a
case.
pro se motion or an attorney in the immediate post plea period?
I'm not sure about that, but
Doesn't that make a
in general, a movement, whether it's filed by the defendant or whether it's filed by an attorney, it's still the movement's burden to an obligation to obtain a
if
ruling. And if
Mr. Kelleher, if your post-conviction counsel, isn't this right in front of your face? That this was ineffective representation of post-plea counsel not to notice the motions for hearing or to withdraw them if the client had instructed them not to proceed?
Well, again, we don't know from the record exactly what happened. There wasn't a bystander's report filed. That would have been helpful.
There was nothing to
So-
stand by. The record doesn't show any hearings.
But nevertheless, the case law holds that if no ruling is obtained, the motion is presumed to have been abandoned or waived by the movant, unless circumstances indicate otherwise. And here, it's a rebuttable presumption, but here, nothing indicates otherwise. And defendant had ample time to bring this up if he wanted to proceed on that motion to withdraw the plea. He had ample time, and yet he waited 14 years. It doesn't, I mean, if he could wait 14 years, could he wait 24 years, 34 years? That's why we have these limitation periods. That's why the Post-Conviction Hearing Act sets a 3-year limit in most cases to bring a claim. And I will point out this wasn't an actual innocence case, so the limitation period applies. But the Supreme Court even warned against a danger. It said that a movement who is fully aware of the motion that was filed cannot remain silent in the trial court and then on appeal take advantage of his failure to have the motion passed upon. And that's exactly what's happening.
Right.
Defendant lays quiet for 14 years, and now they're suddenly trying to resurrect this claim that potentially could have been raised 14 years ago, but he didn't. He abandoned it or waived it. And now you can't just bring it back 14 years and say, aha, I went through the record and I found that this motion appears that it wasn't ruled on. That's why there's a presumption that it was abandoned or waived.
Well, let me start with this though, because you've said abandoned or waived. What in the record would show waiver meaning an intentional act, other than what you're suggesting for abandonment, meaning the passage of time?
Here, we don't have that in the record, so
It's silent to that.
I would argue abandonment is the more appropriate factor here.
I do think it matters whether the case law you're relying on has to do with a pro se motion or a motion filed by counsel, because it would raise the potential for an argument by PC counsel that post plea counsel was ineffective for letting those motions lapse.
Well, we don't know that because it's just as likely that defendant decided not to proceed on them because he realized that he got a mid-range sentence. He didn't want to just risk it all. He didn't, there's nothing in the record indicates he had a viable defense had he gone to trial. So he would have been rolling the dice, and he may have realized, hey, yes, the appellate court granted me the opportunity to file these motions to withdraw, but now the more I think about it, and now when I really have to make that decision, I don't think I want to take that risk. And that's a perfectly reasonable thing that thousands of defendants in that situation make, that choice. They file motions and they don't always proceed with them because they realize, that the consequences are really risky when a defendant withdraws a plea
Does the
in the
record
absence
show
of a
that,
viable defense.
does the
which
record
wasn't-
show that PC counsel investigated any of that?
No, but PC counsel would have been aware of the law and would have been aware of.
But
There's
you're
a
making a
presumption that
factual assertion
he would
that
be
he
aware.
decided. You're making a factual assertion.
Yeah, well,
Is there, and so awareness of the law aside, is there any indication that PC counsel investigated whether that was a decision by his client as opposed to just inaction by his attorneys?
what we have is the Rule 651C certificate, Your Honor, filed by PC counsel stating the requirements that he consulted with defendant about his contentions of deprivation of constitutional rights. He examined the record in the trial court. He made any amendments to the petition necessary for an adequate presentation of defendant's contentions. And I might add, the only contention that defendant raised in his pro se post-conviction petition was this claim that he thought he had under the Hari case. And it turns out that that wasn't a viable claim. So the case law doesn't even require that. There's a Illinois Supreme Court case, Turner, way back in 1999, says that PC counsel is only required to examine as much of the record of proceeding as is necessary to adequately present and support petitioner's constitutional claims. Defendant was raising a Hari claim.
You can't then make a bad claim if you decide you don't like the pro se claim. And arguing that
Well,
counsel was ineffective when appellate counsel really never got to the merits on appeal because of that dropping of the ball.
the fact that PC counsel didn't advance a winning claim doesn't mean his assistance was unreasonable. Not all of these cases are winners, and sometimes
Absolutely.
PC counsels just have to do the best they can with what he had. And here, PC counsel, this was a plea of guilty. There's no evidence in the record that defendant had a viable defense had he chosen to go to trial. So there's nothing unreasonable about him abandoning his motion to withdraw his plea once he thinks more about it. And there's nothing unreasonable about him abandoning his motion to reconsider sentence when he got a mid-range sentence, 40 years when it could have been up to 60, he got mid-range. So this was a situation where PC counsel did the best he could. He realized the Hari claim was not viable under the facts of this case. So rather than just not filing anything, he chose to do the best he could under a difficult situation. He raised essentially a sentencing issue.
He could not have
Alleging that
argued about the
counsel-
ineffective assistance of post-plea counsel.
But there's nothing in the record indicating that post-plea counsel was ineffective.
Well, there's a motion filed and it's never noticed.
heard.
And I know that you have offered up some speculation as to maybe he
Right.
abandoned it. But I don't know that that would be enough to close that issue.
Well, the Illinois Supreme Court holds that there's a presumption that it was abandoned, and unless there's circumstances indicating otherwise, that then that presumption holds. And here I submit that defendant who has the burden hasn't rebutted that presumption, hasn't shown why, the
Are
the
we about
holdings-
rebutting presumptions at the second stage?
well, there is a presumption, and it's coming from the Illinois Supreme Court, that when someone doesn't follow through and obtain a ruling, they've abandoned that ruling or waived it. And PC counsel has to be aware of that presumption.
If defendant wanted to reinitiate his direct appeal, from what final order could he have appealed?
His direct appeal,
After remand, what final order could he have appealed from after remand?
well, he was admonished on April 27th.
There were two pending motions, so.
So he could have appealed the trial court's admonishments if he felt that he wasn't properly.
No, because there's pending
upon
motions.
remand.
There's pending motions, so we would have said, this is not final. There's pending matters. So when could he have appealed?
Well, he could have appealed from the August 17th date.
Which doesn't even say it's an order by a
2007,
judge. That looks like an administrative.
When the case was
Closing.
closed in the trial court.
Yeah, by whom? By the judge on an order, by the clerk? That's not even clear. I mean, clerks can't deny motions.
Well, the problem here is, and I understand what you're saying. Ideally, we'd have transcripts here, which we don't.
No, you don't have transcripts of docket entries, and that's all we have. There's nothing in the docket that suggests there was a hearing after
Right.
those admonishments, so there wouldn't be a transcript.
And it's assuming arguendo that defendant could have had some claim, say ineffective assistance of post-trial counsel or something like that. Even if we assume that, he still can't just let the clock toll or tick for 14 years. He still has to exercise his rights in a timely manner. And he didn't do that. If he had, say, the case was closed in 2007 and, 6 months later, or before that, he files an appeal and says, hey, I don't know if there's been a final order here. That would be one thing, but he didn't do anything. And that's, there are lots of times in law where people have a legitimate claim, but because they don't proceed in a timely manner, they forfeit that claim. It happens all the time with statute of limitations in criminal cases and civil cases. And this is one of those situations where we don't know for sure whether he did, could have had a meritorious claim. I'm assuming arguendo when I make this argument, but if he did, he still had the obligation, the burden to proceed in a timely manner, and he didn't do it in, within a time that's set by law. So instead he waited 14 years. And I submit, like, if this court allows him to, get relief now after 14 years, say he didn't bring this case in the last couple of years, say he brought it 10 years from now, would this court allow him relief in 2034 just because he didn't exercise his rights back in 2007? I submit the answer would be no, because he's waited an unreasonably unlawful amount of time. And that's why the statute, that's why the legislature imposes limitation periods, because
When do they begin to run?
Well, it depends on the situation, but in this case,
You can answer.
thank you. If defendant really wanted to proceed with his motions and knew that he didn't have a ruling on him, especially, and he's represented by counsel, one of those two, either counsel or defendant, could have motioned up the case or filed an appeal or done something in a timely manner, but they can't just do nothing. And that's what they did here. There's nothing here for 14 years. And that's the crutch of this appeal. That's the big problem. It's not really whether he had a viable claim back then. It's if he did, he forfeited it. And it's a situation that happens many times in law where people, even with meritorious claims, they don't act in a timely manner. And unfortunately, you know, in some even meritorious cases, they're barred by the statute of limitations. And I submit that's what happened here. And because of that, I would ask this court to affirm the ruling of the second stage dismissal, because one of the criteria that the judge used was that this case was barred by the statute of limitations. And I submit that this court can rule on that ruling on that basis alone.
Thank you. All
Thank
right, your
you.
time is up, counsel. Thank you very much.
Thank you.
Ms. Kinstrand, your rebuttal.
Thank you, Your Honor. I'll just go back to what the issue really is here, which is, did post-conviction counsel provide unreasonable assistance? And to that end, is his Rule 651C certificate compliance rebutted by the record? And the clear answer to that is yes. Counsel filed an ineffective assistance of direct appeal counsel claim for not challenging his sentence on direct appeal. Had counsel looked at the docket sheet in the trial court or reviewed this court's March 2007 summary order, he would have seen that the relief was, as this court stated, defendant has filed a motion to remand to the trial court for the purpose of receiving proper admonishments under the rule and in order to file a new post-judgment motion under the precedent of People v. Jamison. The state concedes the error and we agree. Under those circumstances, it's impossible to construct an ineffective assistance of direct appeal counsel, because you can't argue that there were stronger issues he could have raised. He raised a winning issue. He raised an issue that would give him the most direct route to sentencing relief. Under People v. Addison, once you've rebutted that compliance with Rule 651C, which has been rebutted in this case, you don't even need to get to the merits. You remand for further second stage proceedings. So notwithstanding the discussion in opening arguments about the appropriateness of relief, the court can just decide it on those grounds. As far as the other comments of counsel, opposing counsel, you know, a lot of these deal with factual issues. I mean, we don't know what happened on guilty plea proceedings precisely because post-conviction counsel was unreasonable. And I'd also point out a lot of the arguments that the state is making should have been raised in their motion to dismiss the claim, since they also, you know, represented the state in the trial court proceedings and should have in theory been aware of what they agreed to on direct appeal. So a lot of the claims about you know, the merits of what he could have raised to withdraw his guilty plea and those other issues just have never been decided because of post-conviction counsel's unreasonable assistance. And so a lot of the contentions about the client getting cold feet, they're just not appropriate at this stage because we can't make those assumptions. And I also think to the issue of whether there's waiver or abandonment, again, you know, they're not properly decided here because of post-conviction counsel's unreasonable assistance. To the extent that the state cited Rogachev, I would point out my recollection is that that case was a different procedural posture. It was a direct appeal. The issue was whether there should be a motion to substitute judge. There were like 4 separate hearings in which the court told the defendant to put the request in writing. Ultimately, he didn't, and that was abandoned. I don't think that the facts are analogous to Mr. Bonner's case. As far as the statute of limitations, Justice Doherty is correct. If there is no final order to appeal from, then none of this has run. And, you know, arguably this just comes down to a question of whether he should be deprived of his right to direct appeal relief. And based on what happened in this case, where post-conviction counsel, the state's attorney, and even the circuit court judge didn't realize the procedural posture of this case, it should at a minimum go back for new second stage proceedings and the appointment of new counsel to flesh out these issues, raise additional ineffective assistance of plea counsel, or alternatively for the relief he requested on direct appeal. And it shouldn't be too late for that, given the unique circumstances of this case.
So I have a question. So after remand for admonishments, when the appellate court did this or does this, what happens to the original order of conviction that had been entered? Does that disappear? Is it vacated?
I think it has to be vacated, right? Because it's not, it's that he didn't get, there's no question he didn't get 605B admonishments. That's pretty clear from the sentencing. But yeah, I think you vacate the judgment of conviction, re-admonish him, and then there's nothing in the record in terms of a new mitimus being issued, probably because these plea motions were filed. So I'm sure that IDOC is relying on his initial mitimus, but it's really a mess.
What are they holding him on, right? I mean,
Right.
what are they holding him on all these years, right? If there's no final order in effect and he's sitting in DOC. This just occurred to me as I've been listening very intently
Well,
here.
obviously it hadn't occurred to me before this argument, so the alarm bells are going off just to see enough. But yes, I mean, again, this is something that I think is worthy of this court's remand based on either of the grounds. But I don't have anything in the record to answer the issue on the
Sure.
on the reissued minimus. So
Thank you.
yeah.
All right, any further questions? All right, I don't see any. Thank you both for your arguments this afternoon. The court will take the matter under advisement and render a decision in due course. We are in recess at this time.